Good morning, everyone. We're going to get started in just a few minutes with our oral arguments on a few cases. But before we do that, I want to cover a few issues with you. For those of you probably, let me just ask this. This isn't something we usually do, but how many of you have never been to a courthouse or to a court hearing before? Okay, quite a few people. Well, this is a serious, solemn event. So we'd like to ask and make sure that everybody is respectful the whole time. So we don't speak out, don't be talking to others or disrupting. And we'd also like to ask you to take your phones, electronic devices that might make noises, and turn them into either the off or completely silent mode for us, please. All right, as the marshal said, I'm Judge John Stargell. I'm joined today by Judge Molly Nardella, Judge Josh Mize. We had the opportunity when we first started as a court a little over 2 years ago to come here for our first oral arguments, and I had an opportunity to be on that panel. Justice Sasso made it yet? Oh. All right, okay. Is it better here? How about here? Better? No? It's just this way. Okay, is that better? Okay, I gotta get right up to the microphone. So a couple of years ago, we had the opportunity to begin our tenure as a new court in Florida, and Justice Sasso and I sat right here on this panel, and our current Chief Judge, Judge Traver, is here. So shortly after we started as a court, Justice Sasso had an opportunity to be elevated to the Supreme Court of Florida. She had to be replaced on our court, but we have 9 judges now that sit on our court. And just want to say thank you today to so many at Florida Southern who made it possible for us to have a place to begin court when we didn't have a courthouse, and others along the way. Also want to recognize today Justice Lewis, who I see over there. Thank you for accommodating us today and for all you've done and for your service to the state of Florida over the years as well. And then I'd like to recognize the current president of Florida Southern, Dr. Jeremy Martin, for a few words.
Well, may it please the court, I am Dr. Jeremy Martin, the current president of Florida Southern College. It is our delight to have you here today, and thank you for being with us. We are honored and privileged to have you here. It was Florida Southern's great good fortune that Justice Fred Lewis, came here pursuing a passion for basketball, and along the way found and imbued a passion for justice. The Justice Teaching Center is an incredible asset to the college, to the state of Florida, and particularly to the community of Lakeland. But as justice teaching does its work, the challenge for all of us on our campus is to be learning justice throughout our lives as we go forward into the many avenues and paths that these students will go. Thank you again for being with us. We hope you have a terrific day on campus and do good work.
Well, thank you very much. All right, so we're going to call our first case today. Is 23-3992, Joshua Penton versus the state of Florida. With, Christopher Cosden representing Mr. Penton and Mr. Stidham representing the state of Florida.
Good morning, Your Honor. May it please the court?
Would you like to reserve any time?
Please, Your Honor, I would ask to reserve 5 minutes for rebuttal. Your Honor, my name is Christopher Cosden. I represent Mr. Penton, the appellant here, the defendant below. Mr. Penton entered pleas of no contest to a variety of burglary and theft charges, and in a separate case to a first-degree burglary.
Counsel, you want to pull the microphone just a little bit closer?
I'm sorry, Your Honor. Is that better?
Yes. Yes.
Right. When Mr. Penton entered his pleas, he reserved the right to appeal denial of a motion to suppress, which we will be addressing this morning. He also was sentenced immediately after the pleas, and when he was sentenced, the trial court judge announced that he was considering facts that were not in evidence. The trial court judge, I'm at page 522 of the record, beginning at line 5.
Counsel, can I stop you there? Was he considering facts that were not in evidence, or was he considering facts that were in evidence but in a different medium? For instance, he was saying that he considered a video when those facts would have been in the PSI report. Is that how you see it?
Your Honor, the facts were not in evidence at all. And although there was mention of the facts in a police report, which is in the record, the police report itself was never in evidence. It's in the record, but it's certainly not in evidence. The facts that the trial court judge mentioned had not been in evidence in this case at all. The judge said...
It was in the pre-sentencing investigation report, so are you saying that that wasn't enough to be able to consider it? I mean, the pre-sentencing investigation recounted the exact same fact that was depicted in the video that the judge spoke about. Is it your position that it being in the pre-sentencing investigation report wasn't sufficient for him to be able to consider it?
Yes, Your Honor. Had the pre-sentencing report been entered into evidence, which it was not, the court could certainly consider the recommendations, but the pre-sentencing report was not in evidence. Had the pre-sentencing report been in evidence, then there should have been an objection to the hearsay in the pre-sentencing report. There's of course, no exception for hearsay that goes to pre-sentencing reports. The trial court judge...
Was any objection lodged to the PSI was submitted to the trial judge? Was any objection lodged to him considering it?
I don't think there was any objection lodged to his considering the recommendations in the pre-sentencing report, but nobody agreed that they were...
That's not the question. I didn't ask whether there was an agreement. The pre-sentencing investigation report is given to the judge. Okay. Presumably you're saying there were things in there he shouldn't have considered. Did anybody object? Did your client object and say, don't consider these aspects of the PSI, they're not properly before you? Was any objection submitted by your client?
No, Your Honor, there was no objection. The judge announced at sentencing, I'm quoting here, page 522, line 5, "But you showed up gun in hand, and I saw the video in another trial. I remember seeing it."
Oh, no, counsel, I get that. My point is that the exact same fact that the judge recounted from the video was in the PSI. So assuming the judge could consider the PSI, I think that makes a strong case that the error would be harmless, because the fact he saw from the video, or said he saw from the video, was also in something he was perfectly entitled to consider. So in order to find this error not harmless, is that dependent on your argument that he couldn't consider the PSI?
No, Your Honor. The PSIs, as the court knows well, PSIs routinely contain a variety of facts that are not in evidence. PSIs are not prepared by lawyers. They're ordinarily prepared by probation officers, and the probation officer will put in whatever the probation officer wants to put in. That doesn't put the PSI into evidence unless somebody moves it into evidence. The court can certainly consider the recommendations, but the court should not consider the facts. Here, there was no trial, so the facts that the judge announced he was considering were not in evidence in this case. The facts were, of course, not necessary for the plea. The defendant admitted when he entered the plea that he had committed the offenses, but the judge was not simply at liberty to consider anything he wanted, as he announced he was doing, including facts from another trial. Now, that's particularly important here because one line after the announcement that I just read, the judge adjudicated the defendant guilty, and 5 lines later, maybe 10 to 15 seconds, the judge sentenced the defendant. So that was certainly something he was thinking about when he sentenced the defendant. Now, the other issue here, which may be, is certainly at least as important, may be more important, has to do with a motion to suppress evidence. Now, when the defendant was arrested, the officers came to his grandmother's house with a warrant. He could lawfully be arrested, and he was arrested. He was in his room, in fact, in his bed, when the officers went in and arrested him. But the officers also picked up a cellular telephone from the room. Now, we do not know exactly where in the room the cellular telephone was. The officer who picked it up said he didn't remember at the hearing on the motion to suppress. The defendant wasn't certain, but there is no question that the telephone was seized. Now, that, of course, is something the officer should not have done. We know very well that searches and seizures inside a home without a warrant are presumptively unreasonable.
Counsel, if we agree with you, with your argument that the cell phone was improperly taken, was improperly seized, and if we also were to agree with you that your client's Miranda rights were violated by having to give the passcode to that telephone, we were to find that was testimonial, where does that leave us on the question of the dispositive nature of the motion to suppress?
The motion to suppress is dispositive for 2 reasons. One, a substantial portion of the sentence was imposed on the original burglary. Now, the original burglary, the only evidence associating Mr. Penton with the original burglary was evidence that was found on the cell phone. There was a picture of one of the stolen items on the telephone.
Was there not a co-defendant that also incriminated Mr. Penton?
That was in the other case. That was in the second case. In the original burglary case, it was alleged that Mr. Penton and some other people went into a residence, stole some jewelry and some firearms, and then at a later time, a later date, some of the same people went into another residence, apparently attempting to rob somebody.
The co-defendant's testimony about that second burglary involved the first burglary, right? He said we went in with the firearms from the first burglary, didn't he, including your client?
Well, the co-defendant never testified in this case, Your Honor. We do not know, because it's not in the record, what the co-defendant would have said had he been called at trial. Now, I can't speculate about that. I've never talked to the co-defendant. I don't know what the co-defendant would have said had he been called at trial.
But there was never a trial. There was a plea here.
That's correct.
So we're talking about whether it was dispositive.
The co-defendant did not testify at the plea hearing. The only, again, I said this once already, the only evidence associating Mr. Penton with the original burglary was a picture of a stolen item on the telephone. Now, had Mr. Penton not been accused of stealing the item that was pictured on his telephone, then the whole first burglary case, the one where the firearms and the jewelry were stolen, could not have gone forward.
Counsel, I guess what I'm saying is, how do you know that? Anytime there's a plea, you're not going to have all the testimony you would have had at trial, and the question is whether or not the state could have proceeded on those charges. And that's why we typically require a finding or stipulation either a finding by the trial court or stipulation by the trial court that it was dispositive. Here, the trial court didn't make that finding. The state didn't stipulate to it. I understand your client put it in the plea form, and it seemed like he understood it that way, and that might seem like a 3850 issue. But there's no way to know all the evidence that the state had, right? We know that there was, the testimony of the case from the co-defendant. So without knowing what the state would have brought in, how can you establish that it was dispositive, given that there wasn't a finding by the trial court, there wasn't a stipulation by the state? How can we find it was dispositive, not knowing what would have happened?
There was no formal stipulation by the state. However, the prosecutor at the plea hearing said, addressing the defense attorney, other than the motion to suppress, is there any matters reserved for appeal? The defense attorney answered no. Then, prosecutor, addressing the defendant, said, you are reserving your right to appeal the court's decision on the motion to suppress we had a few weeks ago. Other than that, there are no issues you can reserve for appeal.
That goes to,
The defendant agreed. So we have the prosecutor at the hearing.
counsel, that's not my question, right? A statement of the defendant's understanding of what he thought he was reserving is not the same as what is required, which is a stipulation that it was dispositive or a finding by the trial court that it was dispositive.
And I'll augment that. The rule requires that you expressly reserve the right to appeal a prior dispositive order. So there's two requirements, is there not?
The dispositive nature of the order, I think, is resolved by the prosecutor's statement that I just read. The prosecutor effectively agreed that the issues were dispositive.
Counsel, do you have any cases where you can infer an agreement as to the dispositive nature where there is not an express agreement or express statement that the matter is dispositive?
I think in this case, the court certainly should infer that the agreement was dispositive. The agreement went into the plea form.
Counsel, if she asks you a question, or anyone asks you a question, the response we need from you is an answer to that question. The question, she said, is there any case where any other court has done that? If it's no, just say no.
I can't affirmatively say that there is no case. I am not aware of a case. But here, what we should do is we should infer an agreement, as the court suggests, because the agreement was announced. It wasn't, the agreement specifically was not ruled upon by the judge, but the judge certainly accepted the plea. And the prosecutor announced on the record that the defendant was reserving these issues for appeal. I think everybody in the courtroom knew perfectly well
Counsel,
that...
what if this was an issue where we looked at it and everyone could clearly say, oh, this doesn't look dispositive to us, right? Would you still say that the fact that everyone below just said he was reserving it, that we should infer the fact that it was dispositive? Or that we should infer a stipulation that it was dispositive?
Yes, we should. We can infer from the statements of the attorneys and the statements of the judges.
So anytime a defendant says they're reserving an issue and the prosecutor says the defendant's reserving that issue, no matter the issue, we should always infer it's dispositive and able to be reserved?
The way the court asked the question, I'm not sure that I would agree that we should always infer no matter
So how
what
do we
the issue.
differentiate?
But in this case, we certainly should infer.
So how would we differentiate? If it's not what Judge Mize is throwing out there, but you said this one is, what's the rule? When will we know?
It seems like you're saying that we should infer in this case because it really, really looks dispositive. Which
Well,
doesn't seem to me to be a workable
on-
standard
on
for
the-
inferring a stipulation or a finding as to dispositiveness in the lower court.
We should infer here because, first off, on one case, on the original burglary case, it clearly was dispositive. There was no other evidence. Had there not been that photograph, then we would have no other evidence, nothing else in the record that would allow a conviction. Now, what would have happened at trial, none of us knows, and
So
none of us
you're in your
can know.
rebuttal time, just so you know.
Right, thank you, Your Honor. If there are no other questions, I'll reserve the rest of my time for rebuttal, please.
Thank you. Mr. Stidham, you're recognized.
May it please the court, I'm Wade Sidham of the Office of the Attorney General on behalf of the state. Starting with appellant's sentence, I just want to emphasize that there is no fundamental error here for at least 3 reasons. One, the court already talked about that this is not just an incident in the PSI, but one of the incidents that appellant was charged with or was being sentenced for here. It's the second burglary. And then another reason is to look at appellant's sentence itself. Appellant got a guideline sentence at the end of the day. He got 0.895 months, I think, in excess of the minimum mandatory.
Counsel, why would that inform a due process, an alleged due process violation, the fact that the ultimate sentence was within the guidelines? Does that matter to our analysis of a due process violation?
Well, I think in most of our fundamental error analysis in other areas always looks at harm in terms of determining whether or not the supposed error reached down to the core of the case. For
So whether it's
example,
categorical or not categorical.
right. For example, like our cases, this isn't in our briefing, but in our cases with respect to prosecutorial comments, there's case law that says that it's not fundamental error unless a conviction could not have been obtained without the improper comment. In this case, appellant seems to be trying to argue that there's a sort of per se fundamental error if a judge references any fact that hasn't been
How
specifically
removed does
added.
the fact have to be before it gets fundamental?
I don't know that that's really specifically defined, but I think the court would have to look at the impact on the proceedings and the severity of the breach to see whether it went to the core of the proceeding.
I mean, if it was a fact just totally unconnected from this, I know this about you through some public source or third party that the judge wasn't supposed to consider, would that then be fundamental? It seems like you're
If it
saying like
was
this was close
material,
enough.
if it was material, it possibly would be. For example, in Barnhill, the trial court had gone on a monologue about the threat to society from child pornography before sentencing.
What's the distinction between a fact kind of farther outside the universe and a fact outside this case, right? Maybe, connected to a related case, but why is that a good line to draw in terms of whether something is fundamental?
Well, I don't think there is a bright line here, but I also don't think it's workable to have any comment by a judge that references anything.
Well, it's certainly if you said workable, right? So I'm going to
Right.
use that word. Workable is would it function? If you said any comment about evidence not within the case, that's fundamental. That's completely workable. That's like a clear black line rule. Anybody could apply that. 100% workable.
Well, in this case, it is evidence within the case because it is within the PSI. Appellant was witness by witness going into the
Can you
home.
respond to your opposing counsel's comment that the trial judge wasn't able to consider the PSI and therefore it's not harmless?
Well, I don't think that's in the briefing anywhere, and I haven't seen any authority to support that. Judges regularly consider PSIs during sentencing. That's what the PSI is for, is to gather information relevant to the case for
But
the
if there were
judge to consider.
facts in a PSI that, that this is someone with the Department of Corrections who's making the assessment, and if they erroneously included facts or they included things that were from a different case, is that something that a judge should be able to consider?
Well, if it were irrelevant, then no, I would hope the judge would be able to distinguish irrelevant facts from relevant facts. However, in this case, the parts of the PSI that we're talking about are taken from I believe the arrest warrant originally from Detective McNeil. And he describes in detail the investigation. He describes at least 3 pieces of evidence. Well, this goes later to a separate issue. But the PSI facts that we're talking about in this case are from Detective McNeil directly. Originally, I believe, from his arrest warrant, which is also part of the appellate record. And then the last part, I would just address the time. Opposing counsel spoke to that briefly. While it was immediately before the sentence and the end of the hearing, it was essentially a final address to the appellant. The trial court had made the most pertinent decision whether or not to sentence appellant as a youthful offender much earlier, several pages earlier. And when the court did so, it acknowledged that appellant was young. It acknowledged that appellant seemed to have worked on his life, that he seemed to be trying to get his life together. It acknowledged the appellant's remorse. He said that because of the severity of the crimes, which this is 2 life felonies, 2 first-degree burglaries, among many other charges, that due to the severity of the crimes, he didn't think that was appropriate. That's all long before we get to this offhand comment at the end of the hearing about the video, and that was in reference to appellant's claim that he was unarmed during the second burglary. He claimed that also in the PSI when he made a statement for the PSI, that he was unarmed in the second burglary, despite the fact that there was an eyewitness that saw appellant armed, and that is in Detective McNeil's report.
On the motion to suppress, can you just address the merits of the motion to suppress? I think there's some issues on dispositiveness, but as to the merits, it looks like that motion to suppress has a problem.
Well, as to the seizure itself, I just want to
Or the denial
clarify.
of the motion to suppress has some problems.
Sure. Do I deny that the motion to suppress had some problems?
It seems like the granting, the denial of that motion to suppress may very well have been erroneous.
Well, I don't necessarily agree that it was erroneous, and I can go through why. With respect to the seizure itself, while it's true that Detective McNeil was not very specific about where the phone was, the appellant was very specific, particularly on cross and recross. He said it was plugged in on his nightstand
How
while
does
he
that
was
tell us
sleeping.
whether he could reach it? And also, by the time they took the cell phone, he'd already been arrested. And so even if it had been in reach prior to him being secured, once he's secured, it's definitely no longer in reach, no matter how close it is to him.
Well, as to the first part, I think it's a reasonable inference that people are sleep next to their nightstand. I think that's ordinary practice for most people.
Well, hold on. I mean, depending on where, we don't know that he was in the bed at the moment he was arrested. And even if he was in the bed, unless it's a single bed, just being on the nightstand doesn't even mean he could reach it. And that doesn't address the issue of they seized it after they arrested him. He was already secured. He wasn't reaching for anything.
So that's not really in evidence. That it's characterized that way in the briefing. However, Detective McNeil did not remember where he seized the phone. He testified that he arrested appellant, and then he later in his testimony testified that he seized the phone in plain view. And then on cross-examination, he said that he seized the phone in plain view during the arrest. It's not very specific from his testimony. However, we're dealing with an abuse of discretion here, standard here in terms of any findings of fact. And the trial court ultimately found that this was seized incident to arrest, and that appellant was in his bed when the arrest began, and the phone was within reach. And that's ultimately what we're talking about in Gant as well.
Are you saying it's unclear that it was that they arrested him before they picked up the phone?
I don't think that's clear from the testimony. I don't think that he says that this happened after this happened, that Detective McNeil says this one thing happened after the other thing happened. He talks about it later in his testimony, but it's not strictly chronological, and frankly, his testimony was not perfect in general.
What was the probable cause the phone had evidence on?
Well, they were already investigating the prior burglary, for one, which was in the same area, and he wanted to check location data on the phone.
I know, but what's the probable cause you have? I mean, other than just saying people's phones probably always have location data.
Well, in this case, they had a specific prior burglary, at least one, that
Well,
they
had a
wanted to
crime,
check
but
the
what was the
location
evidence?
data.
What was the probable cause that evidence of that crime was on the phone counter?
Well, just that phones go with,
So basically, anybody's phone, there's probable cause as evidence when they commit a crime.
if they're suspected of another crime potentially, and we know that they were suspected of another crime because they also
I think
showed,
that's an important concession, counsel. You're basically saying if somebody is suspected of a crime, there's always probable cause that their phone has evidence on it in the form of GPS information.
if there's suspicion of another crime, yes. Or that, I mean, I think the trial court very specifically says that they don't approve warrants, which is also probable cause standard, based on that line of logic alone. They approve it when there's something additional. However, they said that there was something additional here, and that the detectives were trying to solve other burglaries in the area.
But what you need, counsel, to seize evidence is probable cause that what you're seizing contains the evidence. Not just that he committed a crime, but that the evidence you're seizing has some evidence of, the phone you're seizing has some evidence of that crime on it. Other than just saying, well, people's phones usually have information about what they did or where they were, what was the probable cause that this phone had evidence of the crime on it?
Well, the probable cause found by the trial court was that they could have found location data related to other specific burglaries that
Right,
they
so
were
I'm looking
already
for a clear-
suspected of.
So, counsel, that sounds to me, correct me if I'm wrong, because I want a clear answer, that yes, it is just that phones usually say where people were, and if they think you committed a crime, there's always going to be probable cause to take your phone.
Well, search warrants are also regularly approved for searching phones when there is suspicion of a crime for other reasons.
Well, yeah, when there's suspicion of evidence being on the phone, counsel. Here, I've asked a few times and you've been unable to articulate, right? There was no probable cause that there was evidence on the phone other than the generalized belief that everyone's phone always has or usually has evidence of their location on it. That would seem to me that anytime you believe a crime occurred, there would always be probable cause that their phone contains evidence. Am I wrong?
If the person is already suspected of a crime and you know where the crime occurred, yes, I believe that's
So
correct.
just the mere, he committed a crime, that creates probable causes to the phone.
It's not he committed a crime as in he committed the crime he's already under arrest for. It's that we believe he committed an additional crime. And we know the law enforcement already believed that in this case because they were showing the evidence from this phone to the victims of the other burglary and discussing the burglary with the victims of the other burglary.
Okay. So we believe there's an additional crime, therefore there's probable cause of his phone without any other connection to the phone.
Yes, I would say that that's correct. I don't know that there's any case law 100% finding that on point at this point. I think it is
I think there's a lot of
somewhat.
case law fighting that 100% not on point. Yeah, I mean, that seems to be directly contradictory to the normal requirement that there be evidence that there be probable cause of evidence on the phone.
I think it is reasonable to believe, if there's already other reason to believe someone has committed a crime, there is probable cause to believe that their phone will have evidence of that crime.
Counsel, can you touch on the second prong of the motion to suppress, which was that Mr. Penton had requested an attorney at the time, that the officers kept coming back and asking for the passcode to his phone?
Well, they suggested to him that it would be good for him to unlock his phone, and he ultimately did unlock his phone. I think the key point there is that appellant never communicated his passcode to law enforcement. He in fact refused to communicate his passcode to law
But
enforcement.
Is it not-
hearsay recognizes that actions can be words, does it not? Don't we have an entire hearsay exception based upon the belief that sometimes your actions can be an expression?
Counsel, building on that, haven't courts disagreed on that? Isn't there an open split in both the state and federal courts on whether that's testimonial right now?
Sure, I'd love to talk about the split for a second.
I'm not sure which one he's going to answer next. So go ahead.
Well,
Let's
I
start
think
off
that case law is highly instructive. For one, I don't think most of the cases at the state level maybe all of them are good law anymore after the Supreme Court's decision in Garcia, in which they held that, first of all, this is not a settled matter of law, and second of all, there is no irreparable harm, because in these cases, trial courts were ordering defendants to unlock their cell phones. That's what all of these cases are about, and then the defendants filed petitions for certiorari. The one exception is, I'm blanking on the name, but the second DCA case, Stahl. In that case, the state actually filed a petition for certiorari after the trial court refused to order a defendant to unlock their phone. So all of these cases are taking place in the context of legal compulsion to unlock a phone. So they're different in that respect from the start. But for another, Garcia clearly holds that given that all of these were based on petitions for cert, and given that there is no irreparable harm and there is no clearly established law, none of these cases should have been decided that way. However, I'd also like to speak specifically to Pollard, because there's a quotation from Pollard that appellant uses that entering a passcode in the phone is the same as speaking it to someone. However, the actual original quotation that Pollard relied on was subpoena instructions, and those included the additional requirement that it must communicate a fact. And then Pollard removed that requirement when it got to the section about entering it into a cell phone. Now, if you were texting into a cell phone and sending it to law enforcement, I would absolutely agree that that's testimonial. But I also want to emphasize that there's a problem that the trial court recognized, that there really isn't anything to suppress here because law enforcement didn't search his phone when they unlocked it. So law enforcement went and got a warrant, which is not challenged anywhere, a warrant after they got the phone unlocked, and then they searched the phone. So the evidence that we're talking about, which isn't dispositive, but that evidence, regardless, was only found after a warrant that wasn't ever challenged. So there really isn't, as the trial court found, there really isn't anything to suppress here to begin with. If you'd like, I'd also like to speak about the dispositiveness briefly. There's been a lot of implication that just because there was a link made from the ring to the earlier burglary, that the entire case was therefore dependent on the earlier burglary. The ring was one charge out of 16 in the original burglary. There were also 14 counts of grand theft of firearm. And beyond that, appellant never moved to suppress the testimony of the co-defendants or the fact that the victims identified one of the stolen firearms in video of the second burglary. So they used the firearms from the first burglary in the second burglary. And the victims in the first burglary identified the firearms. So the ring wasn't even the only identification between the two burglars. So there are lots of reasons that we can decide just based on the record we have that this was clearly not dispositive.
Counsel, if we agree with you on the question of whether or not the order was dispositive, and we look at the plea form, and let's say we have the defendant who subjectively tells us that he thought he had a right to appeal, which he reserved on the plea form, as an equitable matter, which is what your colleague was getting at, where do we put that if we were to find that was a subjectively held belief that was reasonable? Is that a matter for 3850? Where does that go?
So if it was reasonable, I mean, I can understand how that raises some equitable concerns. However, we're talking about an exception to the general rule that if you plead to a crime, then you can't appeal. This is a carve-out. And when you're trying to reach into a carve-out, I think you have to specifically reach the terms of the carve-out, and that's not true here. And also, as was already mentioned, this could potentially be a 3850 issue if the appellant can show that it would have actually made a difference. But that would, again, run into the issue of dispositiveness.
That doesn't really address the equitable question Judge Novell asked you. Looking at this record, it seems clear the defendant thought he was reserving this issue, and it seems clear that the prosecutor in the trial court either let him believe that he was reserving this issue. Nobody disabused him of that notion. They reinforced that notion. So what you basically said is, well, the requirements weren't met, and we heard your argument on that, but that doesn't really address what Judge Novell asked is, what do we do with that? That we have a defendant who clearly believed this, and a prosecutor in a trial court who seemingly could tell that because everybody said it out loud and nobody told him otherwise.
Well, sure, if he believed this in good faith, then I certainly understand how that seemed unfair to him. However, I don't know how that leads to any remedy in this circumstance, given that we're talking about a very specific carve-out created by the Florida Supreme Court that he doesn't meet. I guess that would be my answer. I can understand the equitable concern, certainly. It seems, if he really did believe this and it was reasonable, which I think is questionable, then that seems unfair to him. But
What about the reasonableness of his belief is questionable? He's not a lawyer. He doesn't know the test for dispositiveness. He doesn't know he's got a stipulation.
Well,
Was that just a completely wrong statement you just made? He's got a plea form that says, I reserve this. The prosecutor says, you're reserving it, right? He's got a judge on the dais who doesn't dispute him of that notion. What about his belief was unreasonable at all?
well, because there was lots of other evidence against him besides just this ring, I would suggest, first of
Well,
all.
hold on. So
And-
the question is not whether there was lots of other evidence he was guilty. Her question was dispositive. He's a lay person. He doesn't even know it has to be dispositive. All he sees is a form he's signing, his plea form, where he says, I reserve this. The prosecutor tells him, you're reserving this. The trial judge is on the dais listening on the bench, doesn't say anything otherwise. So from the layperson's point of view, who doesn't know the test that we're applying right now, what was unreasonable about his belief? Is there any argument that's an unreasonable belief in this situation? Not that it was dispositive, but that he was reserving it.
Well, I think it's unreasonable from the perspective of a person receiving legal representation potentially, not necessarily as a layperson. I would agree with you there that a layperson wouldn't necessarily have a reason to understand that. However, in context, I believe that he should have received representation to that effect. If there are any other further questions, I'll rest on my briefs. Thank you.
Thank you. You're recognized.
May it please the court. First, as to the consideration of the PSI at sentencing, counsel represented that the facts that the judge related in the PSI came from an affidavit by a police officer. Now, the affidavit by the police officer certainly would not have been admissible in evidence. So if that's the standard for what the court should have considered, certainly facts related by a police officer would not be substantively admissible. As to the cell phone, two things have to happen before police or any government agent can seize evidence. There has to be probable cause and there has to be a warrant exception. Here, counsel has represented no warrant exception, and the probable cause, of course, for the seizure of the cell phone, it was just a cell phone, we know nothing more about it, was completely absent. So if the cell phone, was improperly seized in the first place, we never have to get to the Miranda violation and we never have to get to the improper search of the cell phone. So the court can simply decide that part of the case on the improper seizure. Counsel represented that the defendant refused to provide the passcode to the telephone. Initially, he did, but at a later time, without going through all of the facts, the officer came back to the defendant and asked him to put in his passcode in the cell phone, and apparently he did it. Probably every second-year law student can tell us about speech action. We don't need to go on about that. He, by his action, gave the officers the passcode.
So can you address the PSI issue in the context of whether the error, if there is one, is fundamental error as opposed to non-fundamental error?
The error was fundamental because the trial court announced on the bench whether he got this from the PSI or whether he got it from a video in another case, it doesn't matter. The trial judge announced from the bench that he was considering this video, his word, not mine, in sentencing.
Does it make a difference that if you assume he could, the video is completely outside the case, the PSI is within the case, but just something you're saying that he shouldn't have considered as hearsay? Since it was within the PSI, if the only issue was that's hearsay, is that fundamental error?
Yes, Your Honor, it is. One of the things that is most important about our justice system is the appearance of fairness. The appearance of fairness is probably more important than the fact of fairness. When we have a trial court judge announcing from the bench that he is considering evidence from another case, That is about as fundamentally unfair as anything I can
Hold on, but
imagine.
we established, it was in the PSI in this case, and your response is that's hearsay, I understand that. But that does take it out of the realm of this was evidence outside the case, into the realm of this was hearsay within the case, doesn't it?
No,
Is
Your Honor,
considering a
it
piece of
doesn't.
hearsay in a PSI fundamental error that reaches down into the heart of the trial or the sentencing?
In this case, it does, because the trial court judge announced from the bench he was considering a video from another case. That is about as fundamentally unfair as anything I can imagine. So I would ask the court to please reverse the convictions, and if the court does not reverse both convictions, I would ask the court to remand the case for resentencing by a different judge. Thank you very much.
Thank you, counsel.